Let's now get into our panel discussion for tonight. We're looking at both the Madlanga Commission and the Ad Hoc Committee in Parliament, where National Assembly Speaker Thoko Didiza has blocked an attempt to subpoena alleged political fixer Brown Mogotsi and investigator Paul O Sullivan. She says the body, which is looking into allegations of infiltration in the criminal justice system, has ignored Mogotsi's repeated requests for security. For more on this, we are joined by Unisa criminologist Professor Mofokeng, legal expert Mpumelelo Zikalala, and governance expert Professor Theo Venter. You also can join in on this conversation by giving us a call on 010-594-6010 or send us a message on WhatsApp to 072-110-5584. Gentlemen, a very good evening to you. Thank you so much for your time and for joining us today. Let's perhaps start with you, Advocate Mpumelelo Zikalala, when we speak about just the legal principles that are governing the issuance of subpoenas, especially when it comes to witnesses such as Brown Mogotsi and Paul O Sullivan. Just talk to us, considering their security concerns, one currently being overseas, the national speaker saying they were not given, especially when it comes to Mogotsi, enough of an ear with regards to what their reasons are. What's your take on this?
Good evening to you. It's just a correction. I'm not an advocate. I'm a legal practitioner.
All right.
However, it must be looked at it within this particular context. Remember that the legislation is there to subpoena any individual. But the speaker is very clear in terms of saying you must try all other alternative remedies and only come to me when it's the last resort. Now, in this case, you have been privileged that there are other ways and means in securing the attendance of another individual. There is virtual sittings that may be there. There is submissions written that can be extracted. But most importantly, the speaker is saying, try those alternative means before coming to me, but at least convince me that you want a person to come and speak directly to you. Yes, they are going to raise their concerns in terms of their security, something in which is natural in the manner in which we do things, and they must be attended to, unless if they are looking for extravagant things which are going to be very expensive. Then the speaker can come back and say, well, we cannot be able to provide that, let me subpoena you. But before you subpoena, make sure that all those other alternative remedies are available to the individuals concerned.
Prof. Mofokeng, maybe let's bring you in here with regards to under what circumstances can safety concerns legitimately override parliamentary subpoena powers, and how are these typically balanced in a democratic system?
Well, good evening, Katlego, and thank you for having me, and good evening to fellow panelists. It is important for those that are requested to appear before, like in the case of ad hoc committee, to be afforded adequate security as well as, maybe meet them halfway so that they can become willing, witnesses, before they can appear before the ad hoc committees. But, we understand that Mr. Mogotsi, a few months ago, there was this an alleged attack on his well-being. And then as well as Paul Sullivan indicating that also he's having concerns in terms of, his freedom as well as, safety. So that is for that reason that Didiza stated that the committee failed to provide or demonstrate proof that it had properly addressed safety fears raised by both men. So in a case like that, virtual testimony is an option where she cautioned that refusing both these two gentlemen to testify virtually, from Sullivan from the UK or from South African embassy could be seen as irrational and legally viewable in court. So, those who, who did law, of course, they will be able to argue like what Ms. Zikalala also provided to us, in terms of, what is actually required. But if these two individuals then can be seen that, maybe their rights were, they were overlooked in terms of being forced to, to appear in person at the ad hoc committee and something happened to them, probably then, or maybe even, nothing could happen to them. So they can also go to the court of law to say that, well, we understand that ad hoc committee has got timelines to be able to complete by the 20th of February, but their rights also needs to be, brought in the balance of their safety as well as the peace of mind.
And certainly that's a tough act to balance. Prof. Venter, maybe let's bring you in here. Just from a governance perspective, how should Parliament just balance that need for transparency and accountability with the safety concerns that are raised by these witnesses?
Yeah, I would like to build on to what my two colleagues already said. We must remember this is now version 2 of ad hoc and Madlanga. Version 1 was before Christmas, and then there was a break, and then an interim report, and now we continue. Certain things happened in the first part of the investigation, both at the ad hoc committee level as well as Madlanga, where one of the people died in weird circumstances. And I think as people are now called before these committees, they have an experience of what happened previously. And we are seeing that some of the people that are subpoenaed or called for testimony, they are now far more suspicious and maybe far more trying to find out what to do and what not to do. So what we are seeing with O'Sullivan and what we're seeing with Brown Mogotsi, I think plays on to what happened in the first part of the investigations, where people are far more worried about what happens, especially at the ad hoc committee level, where you see Madlanga Commission is far more structured. It's clearly a legal process, and you can see how the legality plays out. But in Parliament, it's far more free for all, and very often politicians not only ask questions, but they make a lot of statements, and a lot of these statements can be very dangerous over time.
But Prof. Venter, I mean, many of those parliamentary ad hoc members have argued that the security that is being offered to Brown Mogotsi, for instance, is quite adequate. It's the very security that they too use. And so their argument is that it's sufficient to keep him safe while coming to testify.
And I agree with them in a large measure. But since there has been a history, and Professor Mofokeng already referred to that, I think Mogotsi has something to build on his case. So one must look at these things in terms of their merit, and there might be some merit in it. And I think that's why Thoko Didiza, the speaker, said to them, guys, what is needed here is not a power play. What is needed here is a little bit more of a flexibility in terms of how you get the information that you want.
Mr. Zikalala, maybe if we talk about precedents, because I think that is also quite a concern that many people have. Of course, I mean, the ad hoc parliamentary committee should close by the 6th, which is at the end of this week. But a precedent would then be set for many other ad hoc committees and other people that would then have to appear before Parliament. What do you think this refusal to issue the subpoenas to both Mogotsi and O'Sullivan set for parliamentary oversight and just the authority to the committee?
But basically, the Speaker of Parliament was setting down the rules in terms of saying, yes, I can issue out subpoenas, but there are going to be rules that need to be followed. There are certain procedures that need to be done. If I issue out a subpoena, it must be on the last resort. You've tried all other avenues, they failed. Let me paint a scenario, for example. They've asked Mr. Paul O Sullivan to join virtually. After joining virtually, there were glitches with the network. Maybe they call him for the second time, or maybe they determine that he's with someone else in the room, or there's someone else who's giving me information. Then you can come back and say, Speaker, we've tried all these other alternative avenues. We've received his written statement or in the form of an affidavit. However, we're still to cross-examine it. There are certain questions that we have, and he hasn't provided any responses to them. Can you please get him to come here? His information or participation is valuable. It's going to assist us in coming to a conclusion. Time is running out. In order for us to conclude, we need your assistance. If you haven't shown all those initial activities that you have done, then unfortunately the Speaker is going to come back and say, go and try those alternative avenues first, and then you can come back to me, and then I'll be able to assist you. But I'm not going to issue out these subpoenas willy-nilly. It's only going to be done in exceptional circumstances after you've been able to convince me that indeed you do need one. And in this case, I don't think the Parliamentary Committee has been able to do so.
All right. Well, let's take a quick ad break. And when we come back, we hopefully will get some of your opinions with regards to today's conversation, particularly with the National Assembly Speaker Thoko Didiza refusing or not quite inclined to issuing out those subpoenas for Brown Mogotsi and Paul O Sullivan. To stay with us. Welcome back. We are exploring that which happened at the Madlanga Commission today, as well as that at the Parliamentary Ad Hoc Committee with regards to those subpoenas for Paul O Sullivan and Brown Mogotsi. We do have a caller on the line, John in Josine. A very good evening to you. What are your thoughts today?
Good evening. Thank you very much for your viewers and the panel members out there. My thought is going to be very much brief, and I'm thinking that Mr. Paul Sullivan and Mr. Brown Mogotsi are making mockery of our justice system and all the process that has been placed in place to uncover the truth as far as what the Lieutenant General Mkhwanazi has alleged. They know that there are so many loopholes and there's nothing that will be done against whatever that they're trying to do. And the politicians are really falling into their traps. We are really dancing as if we don't understand and know the emergency that comes with the allegations that have been made and what should be achieved by all these processes. It's so sad for a common man like me and others who are sitting by the benchmarks of these countries, in the villages, in the townships, or wherever in the corners of South Africa to witness what is happening. We would have hoped and wished that things are going to be different this time around. People are going to be serious, from those who are making laws, from those who are making regulations, and making sure that this process unfolds in a very, very, very dignified manner. But that's not the case. It is so sad to witness. Thank you.
Thank you very much, John. Raising a very important point, Professor Mofokeng, with regards to what he describes as a mockery to South Africans and the Parliament of South Africa with regards to Mogotsi as well as Paul O Sullivan refusing to appear physically. What do you think this does to just the morale and the confidence of the public when it comes to such committees?
Well, indeed, it will put a lot of questions to the public in terms of, the powers that the Parliament could have, in terms of the ad hoc committee to be able to bring those that are supposed to be there, because without these key witnesses, the committee risks failing its mandate. But however, the Speaker's office maintains that rushing a subpoena without, demonstrating a proof, of due process could lead to the entire probe being overturned. So here, these two individuals, they know their rights, and then they use the same constitution that we also praise to say that it is the best in the world, to be able to defend their rights, to say, well, there is a possibility that, their safety will be compromised. But I think, Katlego, what is important is, especially for Mr. Mogotsi, is for the ad hoc committee to be able to probably define, as well as indicate what is it that for them to consider as reasonable, protection. So they need to be able to write to him and as well as rejecting his offer or whatever that plea that he is making towards the portfolio committee to say that, well, the state has this kind of capacity, and then to be able to secure, your safety as well as your peace of mind. So in a case where after they make submission of reasonable security, then he feels that indeed then he needs to go or not come, then it is for the prerogative of the ad hoc committee to be able to make such kind of decisions. But it is also important that, they could meet Mr. Sullivan halfway to say that, well, you're still going to submit. They will still need to ask those questions that they will be able to ask when it's in person there. Perhaps then the issue of ego, in this particular instance, then should be, maybe compromise for the sake of South Africa that will need to hear these two gentlemen, making submissions, because at the end of the day, we want the truth, even though we are now confused in terms of the testimonies that were provided both at the ad hoc committee as well as Madlanga Commission. We no longer know now who's telling the truth, but nevertheless, they still need to say their stories.
Prof Venter, Prof Mofokeng says we need to set egos aside and just hear these testimonies. But could the Speaker's decision be influenced by political considerations, and how might this influence impartiality?
Yeah, no, I think he made a very important point, but let's take a perspective on what we have on both of these investigative bodies. The one is a commission, the other one is a parliamentary process. I think in both cases, the broad outlines of what they're investigating, it's fairly clear. What they're currently doing, it's like a puzzle. They're now filling certain holes, and these holes may be significant, it may be interesting, and so on and so on. So I think it's important that nobody must be left out. Therefore, I will support the idea that get the guys to talk, whether it is virtual and whether it's with bodyguards or whatever, but let them talk. Don't fall into that game, because what is needed is for the Parliamentary Ad Hoc Committee to advise Parliament what to do, and for the Madlanga Commission to provide the President with certain ideas and certain recommendations that he can implement. So in the end, these two things will get together in cabinet, so to speak, because somewhere along the line, there must be some form of alignment of what they found.
All right, we've got Sanele in Mnambiti. Sanele, very good evening to you. What's your take on the subpoenas of both Mogotsi and Paul O Sullivan?
Greeting to you, my sister, and all the panelists, my sister. My sister, I'll be just short on this one. Firstly, I have to appreciate the Speaker Thoko Didiza with the decision that he has taken today, because really, I wanted your panelists even to me just to make me understand what's the difference and why did they want these two to come physically and personally to the committee? Because even the high institution of this country, they are using the virtuals for the court, to take a decision on a very, very important decision. So for them to say that they must come here, and again on this one, I want to understand, what does this mean to the parliamentarian of our country versus the decision of the Speaker of the Parliament too? And secondly, I don't think ANC particularly and the government of this country who want Paul O Sullivan particularly to come there and raise whatever. And even on the case of Brown Mogotsi, no matter we can say whatever we can say with Brown Mogotsi, but we must understand that Brown Mogotsi were running the most special event of the ANC, using the state resources, because they were using them to call in a late term. They were washing the state refunds using Brown Mogotsi's side.
All right, Sanele, thank you so much for your time and calling in this evening. Zikalala, maybe let's just close off this part of the conversation with some of the pointers that Sanele put out. And he spoke that, many of our courts are already conducting their sessions virtually. And he says, what's the difference if someone is appearing physically or virtually? At the end of the day, it's about getting that information. From a legal perspective, does it have an impact? Does it make a difference that you sit across the person and you see their demeanor, you see what it is that they say and how they say it?
You're quite correct. The demeanor being the most important one, to say, how did the person look and sound when they were answering my question? But most importantly is this one. Is the person who's standing on the other side of the screen who's giving out these answers, or are they your original answers, which is the most important one? And what I think the committee might have said, we are scared that you're not going to give us information. Someone is going to be there influencing you as to what to say. So on this basis, we want you to be here. But to make that allegation without any substantial facts, any substantial evidence, is a bit risky. And especially looking into the manner in which Parliament has gone and virtually, our courts have gone virtually, there are ways of making sure that you're able to protect against that. But before you go to the Speaker, you must have at least have tried it, and it must have failed, and then say to the Speaker, we've tried all that we could, but this is where we are now. But right now, They haven't tried any of those, and their best option would be to go virtually. And if there are complications, then come back and say, Speaker, we've tried, there are no other alternative means. We want to hear this evidence, and this person must be here physically.
All right, let's move to the Madlanga Commission now, where today we heard from Police Ballistics Officer Mpumelelo Zikalala. And Mpumelelo Zikalala at some point was speaking about some errors that he had made on a ballistic report. Let's just bring you in there, Prof. Mofokeng, with regards to the significance of ballistics in our country, but also just in the context of the challenges that they face, because he cited that it's a high-pressure job and those mistakes were honest mistakes that any other ballistics expert could have made. But we do know that those mistakes can be quite costly.
Yes, indeed, those mistakes can be extremely costly, especially for, considering the high crime rate in South Africa as well as, violent crime. Earlier, you broadcast on the cash in transit and, how these particular individuals, they are so brazen and they fear nothing. And then they also be aware in terms of the workload, huge workload that are facing, the forensic analysts. We are aware that, they have got a backlog of over 41,000 cases. And, and then they're operating with a half of the staff. Instead of 66, they're operating around 33, analysts, and it is very much important that we need to understand the importance, firstly, of the crime scene, because, if the crime scene has been processed adequately by, by individuals, as those that are, tasked within, forensic labs as well as local criminal record centers where the crime scene is not contaminated, that evidence, whether it's empty cartridges, is very much essential because they are going to test it against whatever projectiles, firearms that have been confiscated to check whether a particular firearm, discharged that particular, because each firearm, based on the manufacturer, it will leave a distinctive marks. It's like one having a fingerprints and tampering, with the property of an individual. So the fingerprints, we are aware that, each individual carries unique fingerprints. The same applies with, cartridges as well as the projectiles of a firearm. So now, if then all this evidence are gathered and they cannot be linked with those firearms, or maybe to determine that a particular crime scene can be linked with, others that happened. So it means that then people will keep on, committing crimes without perpetrators being brought before the court of law and being given appropriate sentences. Now, what we heard about huge workloads, it really compromised the quality, as well as what Captain provided, that for them, it's not about quality, but about quantity. And that really put a lot of, worrisome to those who are waiting, who, the individuals or the family members have been, become the victims of crime. So we need, that kind of, services where those that are leading, these labs are well-trained as well as retained, but as well as those that are commanders to be able to retain individuals that are experts in terms of processing these particular cases, so that those that have committed them should surely be linked with them and given adequate sentences.
Prof. Venter, when we look at these challenges, especially when it comes to resources, for us not to get to where we should be, I mean, Prof. Mofokeng speaks about 41,000 cases that are sitting in backlog and 33 as opposed to 66 people that are working within those forensic labs. Is it a lack of political will, or really are there no resources?
Yeah, I think it's a very important point, and I think it's a lack of planning and a lack of prioritizing, because the worst sentence that I heard today in the evidence was that they're chasing numbers rather than quality. In other words, quantity supersedes quality. Now, the Prof explained to us how important forensics and how important these investigations are. It's really microscopic things. It's really very, very important things where you need highly qualified people so that a case can go to court and obviously you can win the case. But if you're chasing numbers due to the backlog, then there is a problem. And we've heard in previous parts before in 2025, when I think it was the head of forensics that spoke, he also mentioned the lack of capacity and the different things they have to do. I think in the report, the Madlanga report in any case, there will be a very, very strong recommendation that with crime being what it is, and of course that crime is becoming more scientific and more planned and all these kind of things, the state's response should be at the same level, and we are not there. Therefore, many of the cases are lost. And I'm not even talking about DNA and these kind of things that are becoming on a daily basis more important. So yes, if I can do something immediately, in other words, what we use in the business language, low-hanging fruit, I would build out the forensics capacity of the police as a matter of immediate importance.
All right, let's take a quick break. We're speaking there quantity over quality, especially when it comes to ballistics and forensics within our South African Police Service. Do stay with us. We'll be back after this break. Welcome back. We are wrapping up our discussion with regards to some of the highlights that came out today, particularly at the Madlanga Commission. You can join us on this conversation. Give us a call on 010-594-6010 or send us a WhatsApp message to 072-110-5584. All right, so Bab Zikalala, maybe let's just close off that conversation with regards to the ballistics and maybe just your expert opinion with regards to how reliable ballistics evidence is in courts, especially in high-stakes cases involving allegations of corruptions like we are seeing in these cases.
It is very important. Maybe we can start there, because it then acts as collaborative evidence that is provided by independent individuals. So they are taken as expert witnesses when they're caught. So the quality of what they need to bring in court is what matters the most, and it's mostly between the question of finding the person innocent and finding the person guilty. So if you're going to make a hash of an investigation, making sure that you are chasing numbers, the chances of you making a mistake, providing evidence that is going to be rebutted when it gets to the main trial is going to be more. And remember, any case which is lost, there are victims at the end. So it's not just numbers, it's people which are seeking justice. And if they aren't able to get the justice, then they're not going to believe in the criminal justice system which is available to us. So it's important that whenever they engage in such stuff, they make sure that they do it properly, accurately, and in a thorough manner, so that when they present evidence, which the court would rely on it heavily, it's evidence which is accurate and evidence that can be relied upon.
All right, gentlemen, let's close off our conversation with regards to that urgent interdict in the High Court that's been set forward and launched by the Northwest businessman Suleiman Karim. Prof Venter, let's start with you with regards to what's your interpretation of this? I mean, he is asking that the Madlanga Commission not subpoena him to appear before it. This is after he was implicated by other witnesses that had appeared, such as Witness X.
Well, on the face of it, it means he's trying to run away. He's trying not to be there, to be cross-examined or to be interviewed or whatever the commission is doing. And I think if you look at what happened to Mogotsi, Brown Mogotsi went to Madlanga to impress the commission. What the commission did, they broke him down to bare bones. And that is how some of these legal processes are working. They are very, very efficient. And I think Mr. Karim, in my view, and this is just an outside view, I think he's scared that the same thing will happen to him. So he's now looking for protection under the law.
Prof Mofokeng, maybe just your thoughts on this. I mean, Karim wants the commission to fully and properly respond to letters that were sent by the applicant's legal team within 3 days. Some of his requests well within his rights in terms of what he wants, and what picture does this paint about him not wanting to appear before the commission?
Well, I share the sentiments by Professor Venter. I think, he has been following what has been happening there. We have seen, witnesses such as General Sinona, I mean, first they appearing very bold and, very assertive, but, once questions started now, cross-examination, then he was rattled. So probably then he's aware of that whatever that, he's aware of that we are not aware of, then it could come out, and then that is not what actually he wants that to happen. So unfortunately, just, trying to run, but he cannot hide. Then eventually he will see himself then sitting there where others, they face the commissioners.
So Mpumelelo, I mean, he argues that this decision violates the Promotion of Administrative Justice Act, and this breaches the constitutional principle of legality. Maybe just unpack that for us.
You see, the first hurdle that he's going to find is that of agency. Remember, when you go to court on an agent basis, you are saying you have no other alternative remedy, and a balance of probabilities you are going to win. But there are alternative remedies which are available here, and one of them is going to the commission and raising all those your concerns there, and so that they are able to be attended to. The other part of it is the merits. It's like a witness saying that I do not want to be subpoenaed to give evidence because I'm scared that I might incriminate myself. There are processes and ways in which that can be handled, and one of those is to go to the commission and be able to raise those on those ones. So on an agent basis, he may be limping, and it may be the weakest part of his bid. But when it comes to him being called to provide answers, that's the sole basis of the commission. So you must go there and be able to provide answers. And if you can't do so, then it's fine. Remember, we do have a precedent from the Constitutional Court as to what happens when a person does not want to attend to commissions. And the consequences are quite severe. So for him, he may try his legal bid. The manner in which he's been approaching it in terms of saying his rights have been infringed, I do not think it will suffice. When it comes to the Promotion of Administration Act, there are whole processes that need to be followed on that one. And it's quite clear as to what that particular legislation caters for. And unfortunately, it's not for what the Commission is doing. Those are other legal principles that in order for you to ventilate them properly, you need to go to the Commission and be able to answer at the Commission.
All right, gentlemen, thank you so much for your time and your insights this evening. It certainly has been valuable. Thank you for joining us on the late edition. That was Unisa criminologist Professor Jacob Mofokeng, legal expert Mpumelelo Zikalala, and governance expert Professor Theo Venter. Thank you so much for joining us in this discussion, and to you too at home that called in.